Good morning, ladies and gentlemen of the jury. First of all, I want to thank you all for voting for President Donald Trump. I was the first one to congratulate him even before the official results came from India at 1:30 Indian Standard Time. I wanted to thank the American public for realizing what the Democrats were doing during the last 8 years or more. They told us, believe in the rule of law. That is what President Obama and his wife Michelle Obama and the various Democrats told us to believe, but that was not the case. The people are not stupid in America. They understand what they preach is not what they are practicing. I wanted to once again congratulate President Donald Trump on my own behalf and on behalf of my family in India. Ladies and gentlemen, the reason why I wanted to talk to you in my 7th video, David vs. AT&T, David versus AT&T, is how I felt how the Democrats controlled the judicial system in America. And I was made to run from court to court during the last 35 long years with no discovery, no hearing, no trial, from one kangaroo court to the other. Before I go into the legal issues here, I want to briefly touch the facts of the case. In 1974, I and my family, along with the 3 of our daughters, came to the land of opportunity, and we landed in New York. Thereafter, we moved after a couple of days to Detroit, Michigan. In Michigan, I got a job the very first day of my arrival there with a company called Michigan Bell Telephone Company, Detroit, Michigan, located at 444 Michigan Avenue, Detroit. I was hired in as a clerk by the company. I didn't know, unknown to me, they were remotely watching me, maybe others. After working there 6 months as a clerk, my immediate boss called me and said, Mr. David, sit down here, let's talk. We want to promote you, we were watching you, we were very happy with your work. And he asked, what is your background? Because the immediate managers don't get your information, it goes to the central personnel department. I told him back in India I used to work for an insurance company known as New India Assurance Company, Connaught Place, New Delhi. I also happened to work for the retired Chief Justice of India, Dr. Teja Singh, at his residence for a short period. I got married and then we moved to England. What happened was, once I explained to this person my background, he said, would you like to be considered for a secretarial position, which is a management job? And I said, yes, sir. Mr. Temple, that was my supervisor's name, he said, Mr. David, go and take a test and come back, we will talk. I went to the personnel, they gave me a 3 or 4 hours test. I passed that in flying colors. And they said, Mr. David, go and work for this guy, his name is David Barnes. I don't know what national origin he was. When I went to his office, he said, Mr. David, I don't want a male as my secretary. I always had females. 'Cause. 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 ' But at the insistence of the personal department, I was hired by this guy. I worked for him 3 or 4 days. Then he said, Mr. David, you are not suitable for my purpose. I did ask him what his purpose is in having a secretary. Whether to go in bed with them after work or not, I don't know. He sent me back to the department I was working, and my colleagues told me, Mr. David, file a EEO complaint within the company. When I went to them, they said, Mr. David, this guy is 4 levels above us, so we can't take a complaint against a guy who is 4 levels above them. They said, Mr. David, you go to the outside agency, which is known as EEOC, which stands for Equal Employment Opportunity Commission. I went there, filed a complaint. The EEOC investigated and found there is a sex discrimination, a discrimination based on color, gender, age, whatever, no, not age, I'm sorry. Discrimination based on national origin, gender, and they ordered the company to reinstate me and pay me a compensation, which the company did. But they kept this as a grudge against me. I subsequently went to work for 4 different persons. One is Richard Riemann-Schneider, who is a German, Delsley, who is a French, an American black by the name Bob Cooper, and the 4th, an American white by the name Hank Hudson. Hank Hudson, while working there, told me, Mr. David, you are way overqualified. So was the other 3. So there are 2 ways to get promoted within the company. One to go for self-nomination. The other one, we will recommend you. Which one you want? I said, you recommend me. So I was recommended. I went for a 3-day assessment. It's called Intensive Management, or it's called MAP, Management Assessment Program, at which I got a score of 10 out of 10 in each area of assessment. Normally, under the prevailing standards, if a person is found to be qualified in those management assessment programs, he or she is immediately sent for 3 years intensive management training. But in my case, they won't even reveal me the test result for 1 year. The company will not even reveal my test result for 1 year until I request it. During a meeting I had with a personal officer, Mr. Shepard, he told me, Mr. David, you got a score of 10 out of 10 in each area of assessment, but you are not going to be promoted. You are never promotable. I asked him, is it because I filed a complaint against the company? Mr. Shepard kept quiet. So I assumed it is because I had filed a previous complaint of discrimination, the company is retaliating. I went to the EEOC again. I filed a second charge of retaliation against them. I went to the US Department of Justice, which is located right in front of my office, who directed me to go and see one Mr. Bill Edwards, if I remember correctly. And when I went to see his office, he was not there. There was a picture on his desk which showed his wife along with him. And I recognized she is my 5th manager under whom I am working then. So I failed to file a complaint with the DOJ. I came and my supervisor, Ms. Richards, called me and said, Mr. David, we have an opening for you to work for. It's a parent company in Orlando, Florida. Are you interested in? I said, yes, ma'am. They sent me for an interview and AT&T hired me. AT&T at that time had 1,500 employees working for them in Orlando in their antitrust legal department. And Michigan Bell had sent 60 other employees of that company, including me, to work for AT&T. The terms and conditions stated that we will all work for the company for a period of 5 years, and after completion of our assignment, we will all be sent back to the respective companies we came from. That was in black and white. We also had an agreement that they will sell our homes back in Michigan, and they will help us to buy another home in Florida. And they will sell that home when our assignment with AT&T is over. I was subsequently hired by AT&T in Orlando, and I continued to work until August 12, 1981, when AT&T, in collusion with Michigan Bell, elected to fire me from my job for no fault of mine, while giving the 1,500 employees all the benefits. AT&T said, we will give you 3 years salary in a general meeting. They said, we will send you back to the companies you came from in an orderly fashion. But they complied with this with many other employees. They picked me, I being the only person of Indian origin. They fired me after I refused to accept a sum of money offered in the sum of $45,000 in the invited presence of my former wife. The Title 7 of the Civil Rights Act says an employer cannot discriminate you or any worker based on his national origin, color, gender, etc., etc. There is another law passed by the Congress which is called ADEA, Age Discrimination in Employment Act. That act says you can terminate an older worker simply because they don't like you, or they can hire somebody paying half of the salary of the employee whom they are deciding to fire, except for a cause. In this case, I was given continuous merit increases by AT&T. I was getting every 6 months a raise because I was a junior executive. I believe on August 7, 1981, AT&T gave me a merit increase of $5,000 and a fully satisfactory job performance rating. So technically, there was no reason at all for them to terminate me without a cause. It is a violation of the law passed by the Congress, the ADEA, Title 7, and our laws. Now, when I requested AT&T to sell my home pursuant to the agreement, they refused. When I asked them to pay me 8 months' salary as a termination pay as provided in their rules, they refused. Everything I contracted with them, AT&T and Michigan Bell, refused. They want me to sign a release for the sum they offered, which I declined then and there. On August 25, 1981, while I was in Detroit looking for a job elsewhere, I was reluctantly forced to sign a certain release. I'm going to show you a copy of the release. The reason why I signed the release under duress and coercion was I had 4 starving children. My son who is a doctor in Tampa now. He was 2 years old. My other 3 daughters, they were 7, 9, 11. My dependent father with me, my wife and myself. We had a nice house with a swimming pool and everything. We have mortgages, 2 cars to pay, make repayment. So the defendants knew my financial situation and they want to take undue advantage of the same. AT&T is thought to be or told the world is the best company. But when it comes to handling their employees, they are the worst corrupt corporation in America. The ordinary people don't know that, but this documentary will explain the tactics deployed by this mammoth corporation in America. Okay? I was forced to sign a release on August 25, 1981 in Detroit under duress. When I returned back to Orlando, I filed a timely EEOC complaint. I was forced to file a charge of discrimination for violating my Title VII of the Civil Rights Act, ADA, etc. The EEOC, located in Tampa, for reasons best known to them, forwarded my complaint to Detroit, Michigan. I do not know why, because the termination of employment took place in Orlando, Florida. I don't know the reason on earth why this was forwarded by the EEOC office in Tampa to Orlando district, or to Detroit, Michigan, and the Michigan office of the EEOC, without speaking to me a word about it, they decided not to investigate the case as required under the rules. The EEOC is mandated to investigate a complaint, especially when there is a termination of employment resulting from retaliation. Okay? The EEOC's office in Detroit did nothing except to send me a right to sue letter. And based on that letter, I commenced a pro se action at the Middle District of Florida in Orlando under case number 82-200 ORL CIV R. R stands for Judge Reed. The case was assigned to him, and the defendants came up with a motion to dismiss the case, interposing release as a defense. On April 8, 1983, Judge Reed denied the defendant's motion to dismiss. I had by then engaged the services of an attorney from Chicago by the name Syriac D. Kapil, K-A-P-P-I-L. He filed a motion to proceed pro hac quis, which was granted, and the defendant moved the court to dismiss my case based on the release. Judge Reed denied. A copy of the Reed's the denial is shown here. Kapil had previously amended the complaint, my pro se complaint. You will see a copy of the complaint also. Thereafter, defendants deployed tactics to remove my counsel from the case by offering him a judicial position at the Cook County. They are the kingmakers. So when I was sitting in his office, the phone rang. He was on another line, Mr. Kapil. So he told me, pick up David. I picked up the phone. The Bar Council, Cook County, told me that they want to speak to Mr. Kapil. Kapil picked up the phone. They offered him a judicial position, but he declined. Thereafter, defendant attempted to woo my counsel by offering him other cases, so that when they can file a response to a motion or whatever it is, he can build them. He said, no, I'm not interested. Then they threatened him, saying that they're going to make this very expensive, so that being a solo practitioner, he won't be able to handle the case. Folks, to scare him, they propounded 1,130 interrogatories or requests to admit. That is the first step to scare him. Mr. Kapil promptly notified me the tactics of the defendants and asked me whether, Mr. David, will you be able to fund me money so that I can travel back and forth between Chicago and Orlando, file the discoveries and the required things. It is going to be very expensive. So I told Mr. Kapil, I am unable to pay you, I am unemployed, I can't. So we agreed mutually to recuse Mr. Kapil from the case, and I took over pro se. Now, defendant used another tactics. They have to avoid conducting the Rule 42B trial decided by the judge on April 8, 1983, which said he will conduct an evidentiary hearing to determine whether the release is valid or not, pursuant to the standard laid down by the US Supreme Court in Alexander versus Gardner, Denver. The standard laid down by the Supreme Court in that Gardner case is an employer can obtain a release from an employee provided it is given by the employee freely, voluntarily and knowingly. In the case at bar, gentlemen, ladies, you are my jurors, you have to hear this. I didn't quit the job. The release says I quit the job. I was in front of the camera, the television, the newspapers, picketing in front of AT&T, along with my children and my father. I didn't quit the job. I was fired in the presence of my wife, who was invited. So, defendant, they have no way to prove the release is valid. Then they try to do what they call legally a fishing expedition, questioning me and my wife before a notary public. What they call is a deposition, or in the state court they call EBT, evidence before trial. So the 4 days fishing expedition, the defendant couldn't prove a damn. So their next tactics was to influence this judge, Judge John Reed, by bringing a friend of the judge and a former law clerk by the name Anne C. Conway. She is the second gladiator this mighty Goliath had brought in to dissuade Judge Reed from conducting the evidentiary hearing. The first gladiator is Peter Zinova, who was working then for a law firm called Carlton Field, Emanuel, Cutler and Smith of Tampa. So he filed a motion to dismiss, and they brought in the second gladiator, Anne C. Conway, to influence peddle with the judge. The canons of ethics mandated the judge and this woman to disclose to the other party that they are friends They were meeting each other at their homes and other places in private when the litigation was going on. They refused to disclose. From 1982 until 84, the judge did nothing except to deny every discovery sought by me calculated to lead to admissible evidence, while permitting the defendants to conduct 4 days of deposition and propounding getting answers to the 1130 interrogatories. They knew they have no case. They know to begin with they have no case. But they thought they can play Mickey Mouse game with a pro se non-attorney litigant. After seeing the pattern, a clear pattern, especially when we are called for a status conference, judge will say, come into my private chambers, away from public scrutiny. Every time we went there for a conference, there was no conference, he said just bullshitting, okay, in his private chambers. Anne Conway kept quiet. She was the judge's law clerk. She is also a close friend of the judge. She kept quiet. Judge didn't disclose. The canons of ethics mandated them to disclose, which they failed. Seeing the clear pattern, I sent this judge a questionnaire consisting of 20 questions. As soon as he got this questionnaire, the judge called me on the phone from Orlando Federal District Court to New York, where I was then living. He said, Mr. David, this is Judge John Reed. I got your questionnaire. I'm not going to answer them in writing, but I will give you answers over the phone. A federal judge calling a pro se litigant to New York, to Yogesh, New York, where I was then living, and telling me this. I was surprised. But I told the judge, Your Honor, I need permission to tape record your responses. Judge put me on hold, consulted all the people with whom he was sitting. Finally he said, yes, Mr. David. The judge admitted, A, he is a shareholder of AT&T, the same company I am suing. 2, he had worked for Southern Bell Telephone Company, a then subsidiary of AT&T, as its counsel, handling land deals or whatever it is, for several years. That's not really prejudicial. Third one was the bombshell. He was meeting this woman, Anne Conway, at her home. She is my opposite counsel. The judge is meeting this woman at her home. She was meeting him at his office or wherever. He was also meeting him in Atlanta in private. Folks, you've got to use common sense. If a judge is going with the opposite party's counsel, anything can happen. They can go with a handbag full of money, handbag with the money, okay? Full of money, cash, dollars. Nobody sees it. Those years, in 1982, federal judges made $72,000 a year. Which comes to approximately $1,500 a week. How are they going to supplement their income? They can't practice. They got to do some hanky-panky. What Judge Reed did, I have no clue. You guess. What this woman was doing in his home and vice versa, and meeting him in private other places, you guess, people. You guess. Now, there was a trial, one of the one of the conferences, the judge ruled, this is a colloquy you will see between me and Judge and Annie Conway. He said there is a triable issue of material facts axis in the case. A triable issue. So they can't dismiss the case purely on a motion. The Supreme Court has held in the triology of the cases decided by in 1986, when there are triable issues of material facts remaining, a summary judgment cannot be granted to the movement. Okay? Then, so thus the judge became an easy prey to the defendants. The judge refused to conduct the trial or the bifurcated trial ordered in 1983 under various pretexts. You understand? The name of the game here is defendants have no case, they can never prove the release was obtained freely, voluntarily and knowingly. So the judge says, no, I am not going to conduct the trial, the evidence, not the full trial, the 42B trial to determine whether the release is valid or not. That's the first question. I became suspicious, and when the judge disclosed he was meeting this woman at her home and vice versa and other places, and there is a serious conflict of interest, I notified the FBI Orlando. I also sent a complaint to Chief Justice Warren Burger of the US Supreme Court. Within a week or so, Judge Reed recused from the case. And resigned from the bench in utter disgrace. He did one more favor to the defendants by transferring the Orlando filed case to Tampa with another judge with whom the defendants have deals under the table. The Orlando District Court had then 6 fine judges at that time. But they don't want to assign this case to another judge. The standard ruling is, if a judge resigns, dies or becomes ill, whatever it is, the case should be reassigned to another judge in the same court, which the defendants don't want. At the time I was living in New York, the corporate defendant AT&T had their headquarters 199 Broadway, New York. I asked the judge, Judge Hodges, kindly transfer the case to New York where we are living. I am living and the corporate defendant has their corporate headquarters. No. I sent a similar questionnaire I sent to Judge Reed, to Judge Hodges, asking him to disclose his connection to the defendants. Judge refused. I did investigation. Subsequently, I found this judge was working for a firm called McFarland, Ferguson, Allison and Kelly of Tampa for many years. And he had far more conflict of interest than Judge Reed himself had. Folks, I thought this new judge, who is the self-proclaimed judge who wanted to have this case himself, he refused to conduct the evidentiary hearing as was ordered by Judge Reed in 1983. No hearing, no trial, nothing absolutely. In the meantime, defendant had another scheme. Under the scheme, these are all under the table deals. They told the judge, don't do anything until we are doing something, so wait. Put off under one pretext or the other. Defendant, AT&T, terminated a person by the name Orville E. McDonald, who was a division manager working in their New Jersey facilities, who was a former employee of Michigan Bell like myself. They paid him $12,000 under the well-orchestrated scheme. Mr. McDonald filed a state court action rather than a federal action alleging sex discrimination, age, whatever it is. I don't have a copy of his brief. And the Michigan court ruled Mr. McDonald must tender back the consideration paid to him before he can sue. This is what they were planning. The arrangement was get a decision from the Florida court and bring it to Tampa and then get my case dismissed on the basis, which they accomplished. As soon as the state appellate court, in a per curiam unpublished opinion, rendered a decision tendering back the consideration back to the employer is a prerequisite. They brought a copy of the same the day they got it. They submitted to the Judge Hodges, and Judge Hodges, without following any of the procedural requirements, because when you file a motion, the adversary should have 10 days time limit within which to file a response. This judge said these rules are for fools, Mr. David. I don't follow these rules. I am on the payroll of these corporations, so don't worry. Case dismissed. The next day he gets this order, he issues an order. He says, folks, you have to know, if you are a practicing attorney, no judge can render a decision, especially if it is a summary judgment, without giving the adversary notice, proper notice, time to oppose the motion. This judge says, no, these rules don't apply to me. I grant a judgment in favor of the defendant, and he directed, says, if Mr. David failed to pay the consideration back to the employer within 10 days from the date of this order, the case will be dismissed without prejudice. Mark the expression, without prejudice. Folks, you have to understand, there are a lot of people in the scheme. You will see as I go further, everybody is part and parcel of the scheme. Okay? The issue before the court is a discrimination based on national origin, color, gender, age, and denial of my ERISA benefits. ERISA stands for Employees Retirement Income Security Act. That came later on, that issue. Now, this judge issued the order on, I believe, on April 23, and directed the clerk to dismiss the case without prejudice. Without prejudice. The clerk of the court, another agent of the corporation, he changed the order of the judge. He entered a judgment on the merits. On the merits means the parties were heard, there was a trial, there was a hearing, witnesses heard. In this case, nothing happened. Nothing happened. The clerk of the court, by the name Donald M. Cinnamon, entered a judgment. You see the copy of the judgment. Entering the judgment as on the merits. Ansi Conway, gladiator number 2, and Pete Sinova, gladiator number, they were playing games. Folks, being a pro se litigant, I didn't know the difference between these two fine legal terminologies, that is a dismissal without prejudice and a dismissal on the merits. So not knowing these, I filed a timely appeal before the 11th Circuit Court of Appeals. What the defendants did was, they filed a false jurisdictional statement alleging the United States Court of Appeal has jurisdiction to hear the case pursuant to 28 USC 1291. USC 1291 says the Court of Appeal has jurisdiction to hear an appeal provided the judgment of the court below is a final judgment, not an interlocutory order. Judge Hodges' order was an interlocutory order, dismissed the case without prejudice. So, Pete Zinneberg and Conway and a third attorney, they filed a false jurisdictional statement. That jurisdictional statement was also signed by Anthony Heiss and another attorney from Michigan Bell and AT&T by the name Albert Khalili. So they are telling the appellate court, hey guys, this court has jurisdiction to hear this case. Okay? It's a false statement by two attorneys, Pete Zinneberg, who is qualified to practice before the US Supreme Court, and Ansi Conway. And I believe the third attorney was Walbort. I don't know, I can't remember. But you will see from the document. The United States Court of Appeal is required under the rules to ensure the appeal met the requirements, the jurisdictional requirement. Folks, that's the job for which they are all paid. But under the deal, we got to understand, they closed their eyes, they looked the other way around. They slated my case for a hearing before a panel of 3 judges. These three judges are also a panel predetermined by the players. They know in the Court of Appeals there are got so many judges, we have a list of judges there. Now they know which judge or judges they can deal under the table. It is not a random selection of judges. It is all pre-planned. They know which judge will be amenable to their tactics, AT&T's tactics. That's why they are powerful. They know where to grease the palms and who to and how to and how much. You understand? Accordingly, based on this scheme, Judge Robert Vance, who was murdered subsequently, Judge Vance was murdered by a Mr. Moody by sending him a bomb in the mail. So Judge Vance took it, opened the mail at his home, and he was killed instantaneously the same year. The second judge was Clarence Allgood. He got so tired getting the kind of pressure from corporations, he took a gun and shot and killed him himself. You understand? The United States Court of Appeal below the US Supreme Court. 2 judges gone. The third judge, Rory Edmondson. You Google it. You will see the material you wanted. He is a crony. He has a lot of friends. So he renders judgment based on, not on the law, but based on politics. These 3 judges, okay, affirmed one word. I went to Atlanta to argue the case. I was given 5 minutes time. Before the argument began, I told the judges, Your Honors, I've got 6 legal points to be argued, so I need additional time. One of the judges, I don't know who, of the panel said, proceed on, Mr. David, we will read your brief. Okay? At the time, I didn't raise the issue because I didn't know the court had no jurisdiction to hear the case to begin with. So after hearing my 5 minutes argument and reading my brief and the defendant's brief, these three judges issued one word judgment, affirmed. What the court below did was affirm. Folks, I moved to the US Supreme Court with a petition for writ of certiorari. Their bigger game, people don't know, the ordinary people don't understand. The 9 justices then, Judge Scalia died recently, so in 1985, I'm sorry, the Supreme Court denied certiorari. Why? The scheme. I'm going to come to that scheme later on. The scheme actually, as what has happened is, Supreme Court of the United States gets about 7,000 to 8,000 cases per year. So on an average, 666 cases. You think all the judges are going to sit and read the 660 cases on the brief and the response and everything? No, it is humanly impossible. So what they do is, they assign, I don't know whatever the way they do it, they assign cases to law clerks or case analysts, or law clerks mainly, or legal analysts. So if you have a deal with the law clerks or legal analysts, you can easily say they make deals under the table. These guys made very little money. So the corporation, they don't want to lose $15 million to settle a case when they can grease some money under the table to those clerks. AT&T needs only one finger, what they call it, fingers to the working and marble do the talking. Okay? They can easily, the second they get whom the law clerks deal, talk to, they can find out who his or her friend, they can easily go to them, approach them, tell them, hey, something to do for me, and we will give you X amount of money. So the law clerks will tell the justices, there's no case, no merit to the case. So the poor justices, they are not detectives, they are not working for the CIA or the FBI. They are ordinary men and women. They have no time to read and find out the fraud going on behind their back. You understand, folks? So the Supreme Court at the moment has Ruth Bader. She's 83. We have Clarence Thomas, 68. Sonia Sotomayor, 62. John Roberts, the Chief Justice, he's 61. Stephen Breyer, 78. Elena Kagan, she is the youngest Supreme Court Justice now in the US Supreme Court. She's 56. Samuel Alito, 66. And Anthony Kennedy, 80 years old. You think all these justices going to investigate what is going on behind their back? Because these clerks or legal analysts, they are the one going to tell the justices whether this questions presented is worthy of merit. You understand? They don't know what's going on here. These justices are supposed to be blind legally when they interpret the law. But the machinery through which they are getting the feedback is from the clerks, the deputy clerks or the legal analysts. Okay? So my petition for writ of certiorari was denied in 85 by the US Supreme Court, 86, if I remember correctly. Folks, 7 years went by. I was working at a law firm in New York, where I happened to read the Law Journal. The Law Journal gave clearly the distinction between a dismissal without prejudice and a dismissal on the merits. I recognized the order of the Judge Hodges in 1984 was to dismiss the case without prejudice, which is not a final judgment, it is an interlocutory order, which is unappealable. You understand? The defendant's counsel had lied to the United States Court of Appeal. It is a final judgment on the merits. The defendant's counsel had lied to the US Supreme Court, saying that the judgment of the court below is a non-final interlocutory order in their brief. And they told the US Supreme Court, then this court has no jurisdiction to consider an interlocutory order of the court below. But what they are doing is, they are telling the United States Court of Appeal it is a final judgment on the merits and persuading them to affirm. See the gimmicks? They lie to one court and go to the other court, Supreme Court, tell the truth. Telling the Supreme Court it has no jurisdiction because it is an interlocutory order. But that's not what they are doing with the United States Court of Appeal for the 11th Circuit. You understand the name of the game here? I immediately filed a motion under Rule 60 of the Federal Rules of Civil Procedure asking the court to vacate the judgment because the clerk of the court had altered the judgment. The defendants lied to the 11th Circuit saying that it has jurisdiction. But at the same time, defendants' counsel, learned counsel Annie Conway and Pete Silver and Miss Walbolt, who filed the brief, told the US Supreme Court it has no jurisdiction to consider an interlocutory order. You understand? So they are telling one court it is an interlocutory order, and at the same time the same lawyers telling the 11th Circuit clerk of the court it has jurisdiction because it's a final judgment. See the fraud. So lawyers qualified to practice before the Supreme Court of the United States. Liars. Now, based on my motion to correct the judgment, Judge Hodges ordered the clerk to amend the judgment as a dismissal without prejudice, retrospective effect from the date of the original entry of judgment. You will see a copy of that order. Thereafter, Your Honours, ladies and gentlemen, I filed a complaint with the United States District Court. Because it's not a final judgment, I can refile. My complaint was filed on time with the United States District Court in Orlando, as soon as I got my right to sue. So I filed a case at the Eastern District of New York, asking the court to grant me my ERISA benefits to which I am entitled, and also incorporated my unresolved ADEA, Title VII and breach of contract claims. Folks, in every court that I investigated, there are ways to beat the system. The conduit is the clerk of the court or his or her deputy. The clerk sitting in the front desk like a receptionist. They are the first link. They were trained. If it is a major corporation, is the defendant assign the cases to certain judges. They have no monopoly. No judge has a monopoly to hear a particular case belonging to a corporation. Okay, all judges are deemed equal, except if a judge is specialized in scientific thing, he knows certain things, then there is a use to assign the case to a judge. Or is a judge who is a qualified accountant, who has a background. Then that case can be assigned to another judge of that caliber. Ladies and gentlemen of the jury, I forgot to tell you something also which I skipped. After the Supreme Court denied certiorari in 1985, I filed an action against the defendants at the State Supreme Court in New York County under case number 89/378, and that action was for breaches of contract the defendant AT&T had with me to sell my home pursuant to the agreement, to pay me my 8 months relocation, my termination pay, and also other matters, including my relocation payments. That action was defended by another law firm called Robertson Finger. In that action, another general counsel of AT&T by the name Joseph V. Ippolito who is currently a professor in New Jersey, he filed another false statement, another affidavit, stating that the action, the Orlando action, the judge rendered a decision on the merits, which was affirmed by the United States Court of Appeal and certiorari denied by the Supreme Court. You have to hear, these are lawyers who are qualified to practice law before the courts, the highest court in the land. They are lying. He says the judgment was rendered by the Tampa court on the merits, which is not true. It was altered by the clerk. And they filed a false jurisdictional statement, managed to get an affirmation from the United States Court of Appeals, so they did everything through fraud. And this lawyer, Mr. Joseph V. Ippolito, telling the State Supreme Court in New York County, this claim made by plaintiff, that's me, is res judicata and collaterally estopped, and to grant them a summary judgment. Based on their false affirmation, a pre-picked judge who made headlines in New York, the name of the judge was Mr. Picor, Francis Picor. His election was again under mystery. Because I went to the clerk of the court, I said, I want to see the random selection of judges. He said he will let me know by Thursday of that week. I went there, I believe, on Monday. He said they'll do it on Thursday. And he said he will call me when they do the random selection. But as soon as I got home, I had a hinge they may be doing some hanky-panky. So I called another clerk. I said, my name is so-and-so. Who is the judge assigned? So the girl said, it is Judge Francis Picora. So they were lying. They wanted to pick a panel or a judge of their choosing. That's the deal. Judge Picora had made headlines for collecting large money from an insurance carrier whose cases are before him for his alleged fraud in front of the state Supreme Court and for a motor vehicle accident in Long Island Expressway. It was all over the newspaper. So now Mr. Ippolito, the General Counsel of AT&T, files papers saying that this case was decided and dismissed on the merits, which was affirmed by the 11th Circuit Supreme Court. So my claims are barred by the doctrine of res judicata and collateral estoppel. So Picora, based on their pleading, immediately issues a summary judgment dismissing my breach of contract claims. And I didn't know at the time the fraud going on here. A panel of 6 judges of the Supreme Court of the state of New York County, affirmed, and the Court of Appeals for the state of New York denied certiorari. That's the important thing I forgot to mention. Now, folks, after Judge Hodges amended the judgment in 1991, that is 6 years after the US Supreme Court denied certiorari, holding the clerk had made a mistake. So he ordered the new clerk, whoever he was then, to amend the judgment retrospective effect from the date of the original entry of judgment. So the clerk entered a judgment to that effect. So legally, what the judge should have done, Judge Hodges, was either schedule the parties for a settlement or proceed ahead with the trial of the matter. His decision is based on a hatched case law brought in by the defendant from Michigan State Court, which was already overthrown by the Supreme Court of the United States in Aubrey versus Energy. But Judge Hodges did nothing. He issued an order, interlocutory order. Then he said, that's it, forget it, guys. And the defendants played the tricks. Okay? The judge should have continued with the action. Judge Hodges. You can't issue an interlocutory order and then say, forget about it. He should have done his job, which he failed. Okay? Now, since I'm living in New York at the time, I moved to the federal court in Long Island, which is close to my home. I filed a complaint, which was subsequently amended, and the judge assigned, as I told you before, under a scheme. Once you go to the court and give the clerk of the court the complaint, they will look up who is the plaintiff and defendant. Then they go inside, they come up with the name of a judge. Okay? You don't see where is the random assignment. The assignment of cases by the clerks are based on the training they were given. If it is a major corporation, they know which judge should go the case to, so that they can fix it. They don't want other qualified eminent judges to consider the matter on the merit. That's a scheme all over America, every court. There was a fight, I know personally, in New York County, the same issue came up. And there was a lot of murmur among lawyers. Okay, to cut the long story short, this woman, Joanna Seibert, who is appointed by Bill Clinton based on party politics, she got the case. Okay, they know she is the poodle of the Democratic Party, so she got the case. Oh, now the defendants have to seek an attorney who is connected to the political party. So they got a law firm called Fulbright and Jaworski. The firm recently changed from Fulbright to Norton Rose Fulbright and Jaworski. And they got a partner by the name Ralph Curtis Dawson. I call it the Black Month. Now, he has so many feathers on his cap. He is the chairman of the Democratic Party's Rules Committee. He is also a member of the Disciplinary Committee of the New York Bar. So he is so powerful politically. He is a Columbia School graduate with a JD and a Yale University graduate. So he is a powerful person. He is well educated. But what he is doing, you have to understand what is going on in the course. This guy tells his co-counsel, who just graduated from St. John's, this guy's name is Brian Wayne Kilmer. Brian Wayne Kilmer. Kilmer filed an affidavit, a false affidavit. So this idiot is new. He was licensed a year before, 2006. He prepares an affidavit. I'm going to show you his affidavit for your benefit. In the affidavit, he says he has personal knowledge of the facts stated herein. That is the first sentence. He has personal knowledge. Then he goes on to say a lot of things, including on item number 3, on August 25, 1981, Mr. David signed a release in Michigan. You have to hear this, gentlemen, ladies. Then he is telling how they managed to get the judgment from the Taba court, which was on the merit, which was not in fact on the merit, it was altered by the clerk of the court, which was affirmed by the United States Court of Appeal. The United States Court of Appeal had no jurisdiction, and it is affirmed and the cert denied by the US Supreme Court. So he is testifying, he knows all of these things. When I checked his credentials, I found this kid was born on May 5, 1979. When I signed the release in 1981, how old this kid was? this white honky. 2 years old. '79 years old, he was born. I signed a release in '81, and New York, this kid was living, Brian Tilker. I signed a release 663 miles away from New York. He is testifying to the federal judge. Judge, I have personal knowledge about all the things he stated in his 3-page affidavit, which is false. And this vampire judge, Seibert, grants a summary judgment based on this 2-year-old person's affidavit. Simply because he is now a lawyer, he can't recall what happened in 1981. Okay? His testimony was totally false and perjured. You understand, folks? So this woman, this crazy judge, this rotten wood should be removed by President Trump immediately. She grants a summary judgment solely and only on the basis of this 2-year-old person's affidavit. I filed a motion before her, and she says Tilker can testify, so that is customary for lawyers to file affidavit. To overcome a motion for summary judgment, or to support, in support of a motion for summary judgment. You understand? We are going to read from paragraph, or going to show to you what a ruling and justification for accepting 2-year-old Tilker's affidavit. Ladies and gentlemen of the jury, you've got to be careful to listen to me, please. If you are a lawyer or a judge or a jurist or a law student, understand. The Supreme Court says a motion for summary judgment cannot be granted if there are triable issues of material facts exist in a case. That was the holding of Judge Reed. There is a triable issue. But this crazy woman, she says Tilker's affidavit is sufficient, and she cites in her 19-page order Tilker affidavit 12 places. The basis for granting a summary judgment shall not be on the basis of a hearsay evidence from a 2-year-old child. You understand? Ladies, gentlemen, jurists, you listen to. This woman, he is a disgrace to the entire judiciary in the Long Island, in New York. She should not be permitted. She should be forced to retire. She can't decide a case without a trial. I asked her, I want discovery, and there is a colloquy between me and her. She says, no, Mr. Discovery, I will consider after the motion for summary judgment is decided. It's like telling you, I'll put the cart before the horse. Discovery should be granted before the trial or before the motion to be considered. She says no. You will show you the colloquy between me and this woman and Mr. Dawson, who never came to the conference, pre-motion conference. Neither Mr. Dawson nor Mr. Tilker ever appeared in the federal court during the 7 years the case remained in New York. You understand? They accomplished everything through the Charlie's Angels. The people, they can pay under the table. They are the Charlie's Angels. So they don't come to the court, never, ever. People should ask, if a lawyer don't come to the court, they got two lawyers, Tilker and Mr. Dawson. They never, ever came to the court. So everything is done under the table through the angels. Folks, what happens? This crazy woman issued a second order denying reconsideration. I promptly filed a motion to proceed in forma pauperis with this woman, because once you are terminated by a corporation in America, employers think there is something wrong with this guy. He's, they try to create sort of panic. They badmouth so that nobody will hire a person who was dismissed. That was even with the US government. They refused to hire me, then I threatened to sue them. I didn't even have a parking ticket. That's why I was hired eventually by the Internal Revenue in Miami, in the appeal division. Okay, I worked there for 1 year and I quit the job because it is not only the least paying job, but there were a lot of other problems which I recognized. So this woman rendered the decision, and I asked her to allow me to proceed in forma pauperis, although I was unemployed. She denied arbitrarily and capriciously. Then I was forced to pay my filing fee out of my meager unemployment benefits to the United States Court of Appeal for the Second Circuit. Now the game is there. As soon as I file my notice of appeal and paid the fee, we get an order from a person whose initial is DH. DH, in the general docket sheet entry, you will see the regular case manager who was there. They moved her somewhere and they brought a new girl by the name Anna Steglich to be the new case manager. The sole purpose being to get a panel of the defendant's choice so that judges who are qualified and competent, who are having no prejudice, they won't get the case. They want the case to go to a panel of the defendant's choice. So the appeal went to a predetermined panel of judges, namely John Walker, United States Court of Appeal for the Second Circuit, Rina Raggi, and Judge Rakoff. He is a district judge sitting by designation. Now, when you raise the issue before the Second Circuit Court of Appeals, the panel should at least respond to the questions raised. One of the questions I raised was, how can a 2-year-old person testify and on the basis of that a summary judgment be granted? The other thing which I raised was, under the canons of ethics, under NYCRR 1200 8.4, an attorney cannot be a witness in the same action. Tilker filed the motion for summary judgment. He signed it on behalf of Mr. Dawson. Then he testifies as a witness. He can't do that. The rules do not permit. The NYCRR 800 8.4 says a lot of things there. What lawyers cannot do to persuade a judge to get a judgment, which is unethical. Okay, folks, we are going to show you the canons of ethics. So these two lawyers, this black monkey and the white honky, broke every law, every canons of ethics. Folks, there is a big fight going on with the disciplinary committee of the New York Bar, where they close their eyes if the crime is committed by major law firms.
With the DDC. The DDC is the Departmental Disciplinary Committee for which I used to work. I was a former principal attorney there for 6.5 years. I alleged that upon learning of the DDC's pattern and practice of whitewashing and routinely dismissing complaints leveled against certain select attorneys to the detriment of the public that the DDC is duty-bound to serve, I reported this wrongdoing pursuant to my rights under the First Amendment to the United States.
Well, they have the feathers on their caps, like Mr. Dawson. Okay? What Mr. Dawson and Tilker did was commit perjury. Perjury. Okay? Now the Second Circuit, without addressing any of the issues I raised on appeal, simply affirmed, like the 11th Circuit Court of Appeal did. Okay? The purpose of selecting the panel is to enable the defendants to walk away scot-free. That's the secret process. You understand, folks? American people are not stupid. If they were, they wouldn't have elected President Trump hearing the lies of the Democrats. They said the rule of the law. This is the rule of the law. What is going on in the courts? Do people get justice in America unless they resort to violence? Everybody cannot be moody to send a bomb to the judges. You understand? I come from a country of Mahatma Gandhi, who taught us the principles of ahimsa, non-violence. While I am living abroad on a self-imposed exile for the last 6 years, is because there is no way you can get justice there. Folks, you got to understand. Now, this panel affirmed, and you will see a copy of the judgment of the United States Court of Appeal. Folks, one more thing I forgot to mention. Judge Walker subsequently went to AT&T premises, going through a dirt road to Connecticut. Okay? He killed a policeman who was guarding the premises. What was he doing there in AT&T premises, going through a dirt road? I've gone to Connecticut 100 times. You don't have to go through a dirt road. You don't have to kill a policeman guarding AT&T premises. Did he go there to pick up his reward? The present media said, is the judge above the law? The judge was never arrested. He was never tested for drugs and alcohol. To kill a policeman, and he goes scot-free. The United States Court of Appeal Judge John Walker, he goes scot-free. Okay, now they move to the Supreme Court of the United States again. That's the 4th time. Supreme Court, as I told you before, they have a printing machine which will say petitioner, defendant, certiorari denied. You know why? As I repeatedly told you in the previous recording, these judges, these justices, they call justices in the Supreme Court, judges in the court below, these justices don't have the time to read the 7,000 to 8,000 briefs and supplemental brief and all these things. They are human beings. They are not mechanical instruments. I feel sympathy for the 8 justices currently occupying the Supreme Court of the United States. Okay? Some of them are very old, 80 and 83. That's too old, I believe. They should be resting. They should be relaxing at their old age. I don't say old age, 80 or 83. It's not an old age in America. They don't understand what is going on behind their back. The players are the clerks of the court, or their deputies, or the legal analyst. So they don't bring cases in which you raised issues of paramount public importance. After the US Supreme Court denied certiorari from the New York action, where the Judge Seibert ruled against me, and the United States Court of Appeals for the Second Circuit affirmed, I filed a petition before the US Supreme Court. That's the 4th petition. There is one common thread in all these things. There is one particular law clerk or case analyst by the name Melissa Bladdock. She is the common thread. So I don't know what she advised the United States Supreme Court justices, okay? Because as I told you before, the 9 justices minus Justice Scalia, the justice who recently died, they, as I told you, they can't go through every file and read everything, 7,000 to 8,000 cases. So whatever these law clerks tell the justices, they have to accept for gospel truth what the law clerks or the legal analysts advise the court. We, the public, have no right to know what they are telling. You understand the whole secret process. So this woman apparently advised them whatever she wanted to. She's not telling the court this is a civil rights case, and I was screwed from 1983 onwards by the courts below playing tricks. The deals under the table, nobody knows. The legal clerks, law clerks, they don't tell the justices the name of the game going on in the court below. So the Supreme Court of the United States on November 15, 2011 denied my petition for writ of certiorari in case number 10-6396. And they also denied rehearing on January 24, 2011. Okay? Now what I did was, I am so angry, so vengeful. If I cannot get justice in the United States, I committed no crime. This is not a criminal case, it's a civil case. A corporation fire an employee illegally in violation of all the laws. You are asking the courts to help you, and the courts are all partisan, putting money in their pocket. This is how they fix the cases. These major corporations pay the officials, the various court officials, so that they don't have to pay 10, 15 million to a complaining plaintiff. So, I was so mad, I was thinking what to do. Then by the grace of God, I realized, after doing a lot of research, the Court of Appeal for the 11th Circuit had no jurisdiction to start with. If the Court of Appeals for the 11th Circuit had no jurisdiction to consider an interlocutory order of the Tampa District Court, how can it consider the matter? The defendant's trick, as I told you, was to file a false jurisdictional statement telling the court, pursuant to 28 U.S.C. 1291, the Court of Appeal has jurisdiction, when they knew it is false, because Sinaber, the lead counsel for AT&T, Miss Conway, who is now a judge, a chief judge, she was until recently the chief judge of the same court, and she was quickly moved to Washington to be one of the judges in the terrorist court. Okay? Now, they knew what I am telling is the truth, but these judges who are bribed, they don't listen. The clerk of the court don't listen. Clerk of the court at the 11th Circuit, he is required, I think his name was Miguel Cortes. He is supposed to investigate, or his deputies, whether the court had jurisdiction or not. But they didn't do it, let the case go, and then said denied. As I said before, I located the papers and I brought it to the attention of the 11th Circuit Court of Appeal, where only one judge, that is namely J.R. Edmondson, was the member of the original panel. I filed a petition before that court, and I know I want this to be heard and banked, because the other two justices in the panel, one was bombed and murdered, Judge Vance, and then Judge Clarence Allgood committed suicide. So there was only one member in the original panel, which is Edmondson. And I filed a motion en banc telling the court it had no jurisdiction, so vacate the mandate issued by them in 1985. Okay? Now Judge Edmondson denied the motion. You will see a copy of the motion denying and instructing the clerk of the court not to accept any further papers from me on this closed file. Who closed the file? They themselves did. I didn't tell them to close it. Okay? Now, Judge Edmondson alone, as a single member of the court, cannot direct the clerk not to accept my papers, because I sought en banc consideration, the entire court. I am raising an important issue, a constitutional issue. If the court has no jurisdiction, how can they hear the case? That's an important question. Okay? So, he denied my motion and instructed the clerk not to accept. Despite his instructions to the clerk, I filed 15 sets of papers again, asking the en banc court again to consider my petition, because the court had no authority to start with. Judge Edmondson this time decided to bring in another judge, Judge Stanley Marcus, before whom I had argued another case in Miami against the city of Miami. And Judge Edmondson did the same tricks, because my case was before Judge Marcus, Judge Lawrence King and Palermo, Magistrate Palermo. They were very decent people. I even shook hands with Justice Judge Palermo in his chambers. I was deposing the city. Anyhow, Judge Marcus' decision was overthrown by the United States Court of Appeals for the 11th Circuit in 1986 against the city. Now this judge is in the picture now. He says, along with Judge Edmondson, petition for rehearing denied. Okay? They don't want to address, tell the reason why. If the court had no jurisdiction, how can they hear the case to start with and affirm it? So now I am asking that court, to the same court, recall the mandate, which they don't want. Now, folks, I move to the US Supreme Court. My petition number was 15-9100. And as I told you before, there were Mickey Mouse game there again. The same woman, Melissa Blalock. She, as I told you, and it was already in the other thing, she returned my papers saying that one page is missing. And now the game is, after I called the clerk of the court, one of the clerks, deputy clerks, they decided to put my case back on, because Melissa advised the court, my case is not meritorious. How does she know whether the issue I'm raising is meritorious or not? To dismiss that pursuant to Rule 39.8 of the Supreme Court rules. Okay? That's the name of the game. Now I understand my papers were submitted to the justices for November 22nd, 2016. The issue I raised before the US Supreme Court lately is, if the United States Court of Appeal for the 11th Circuit had no jurisdiction to consider an interlocutory order of the Tampa court, how can the court examine the case, the Court of 11th Circuit Court of Appeal, and affirm the same? I raised several legal issues in my brief. And there is another game. I sent my brief to the US Supreme Court by express mail, registered express mail. In a box, you got to have 12 briefs. Pro se, lawyers are required to file 40 sets. Pro se, you only have to 10 plus 1 or 12 copies at the most, with all the brief and the attachments and everything. I sent it to the US Supreme Court, and this woman, who seems to be having the monopoly of hearing corporation cases, her name is Melissa Blarlock. Melissa Blarlock. I tried to Google, and there are so many Melissa Blarlocks, and I identified one person who used to work for a law firm before and who went to work for Coca-Cola company, then apparently joined the Supreme Court. She is the one who is having monopoly of AT&T cases, or my case. So this woman returned my old damn papers back to me in that box. Saying that, Mr. David, there is a one-page document, one page. I'm going to show you that. That one-page document, which is known as motion to proceed in forma pauperis. One single-page document. That is missing. So I'm shipping it back to you. The woman had my brief. My address is on the front page. My address and my phone number, which is a toll-free number from the United States. Anybody can call me on that number, which is area code 631-841-6222. It is boldly written. But this woman, instead of making a call, a free call to me, to get this one-page document, motion to proceed in forma pauperis, she elected to send it to me, costing the taxpayer $100.05 in a box. You see the box. Okay? Then I got this because I was waiting for a number to appear in the computer, in the US Supreme Court docket. When I saw, I called the clerk of the court. So they connected me to this woman. I asked her what happened to my petition, which was filed a long time ago. So she was giving me a evasive answer, not to the point. She knew what she was doing. Okay? Now, she did one more trick. As soon as I got these papers back from the US Supreme Court, which cost me more than half my Social Security pension to prepare and mail it, I had to redo the whole damn, not redo, just to pack it up and then attach this one-page thing, mail it. The cost of mailing is more. I sent it back to this woman in a cover, in a box. And I sent a complaint to Chief Justice Roberts. A copy of my complaint is here. As soon as the Supreme Court got my complaint, they assigned a case number, which is 15-9100. Now, after my complaint was accepted by the court and assigned a case number, I called the court again. And I talked to a gentleman by the name Mr. Atkins. He was the one I believe, in charge of the Supreme Court of the United States. So I said to him, Mr. Atkins, I have sent the papers second time, and the docket sheet shows my motion to proceed in forma pauperis was denied. Motion to proceed in forma pauperis is denied pursuant to Rule 39.8. And as a result, my brief was dismissed. You understand, folks? Rule 39.8 of the Supreme Court rules state the court can dismiss if the appeal is frivolous. Folks, you have to understand, if it is a frivolous action, they don't have to submit to the court. What I am raising before the Supreme Court of the United States is violation of my Title VII, ADA, breach of contract and ERISA benefits, and dismissal of the action by the Tampa court, which was altered by the clerk of the court as a dismissal on the merit, upon which the defendant moved to the 11th Circuit Court of Appeal to get it affirmed. But what I am telling the US Supreme Court is, the 11th Circuit Court of Appeal had no jurisdiction to consider an interlocutory order of the Tampa court. Is it a frivolous issue, folks? Who decides what is frivolous? The clerk of the court? This woman? She can't decide questions of law. The justices have the right to decide whether I am raising a frivolous issue or not. You understand the name of the game here? So, this woman, the more I research, I find every case, any civil rights case is coming denied. I happened to read a criminal case of a criminal or a alleged criminal. She denied. I talked to the lawyer. I couldn't get any response, although I called them. So what has to be done is President Trump should raise the number of judges from 8 to maybe 25. So the burden of the Supreme Court will be reduced. They should be able to concentrate and understand issues, not listening to the paid law clerks who are prejudiced. They don't get the right information because they are all paid parrot of the corporations. The 8 justices and the Supreme Court rules say granting a petition for writ of certiorari is discretionary. Nowhere in the world the highest court can say we only consider discretionary issues based on our whims and fancies. If people of the United States have to get justice based on the laws passed by the Congress, like ADA, Title VII, ERISA, people will go with no remedy at all. The Democrats have preached rule of law. President Barack Obama and his wife, who are both law professors, they should have read my brief I sent to White House to both President Obama and Mrs. Obama, Michelle Obama, and to my senator, and they keep quiet. This is the rule of the law they ask us to believe in. I was only trying to enforce the laws passed by the US Congress. The Constitution says the courts are there for ensuring your right to liberty and property is to protect them. My right to liberty and property is a terrible peril under the Democrats. President Trump should rise to the occasion, clean up the Justice Department. That's where the major problem. The Justice Department is, I don't call it Justice Department of injustice. They're the bigger game. My complaint against Dawson and Tilker went to a gentleman from India by the name Preet Bahar. He's the US attorney appointed by President Obama. And he says, oh, Tilker and Dawson have not done anything wrong. Two perjurers, this attorney, US attorney Preet Bahar says, they have not done anything wrong. Folks, this complaint against Dawson went to the District Disciplinary Committee of the New York Bar, and a five-judge panel unanimously ordered an investigation against Mr. Dawson. You see the docket. Did they conduct an investigation? The first department of the Supreme Court of New York instructed the second department to conduct the investigation because there is a conflict of interest. Dawson is the chairman of the political party. He is also a member of the disciplinary committee of the New York Bar. So, the second department don't want to conduct an investigation against a political figure because he's Obama buddy, he's the chairman of the political party, and then I get a letter from Mr. Guaido, he's a special counsel. He says, traditionally we don't conduct investigation once the case is decided by the federal court. Folks, do you understand what is going on? Cover up. Lawyers try to lie and get justice for themselves by pocketing nearly $30 million. This Mammoth Corporation, I call the Mafia Corporation, is paid to them to defend an action in which they have no leg to stand. If they had a defense, a valid defense, they had 35 years to conduct an evidentiary hearing based on the two-page order of the Judge Reed. They don't want a discovery. They don't want a trial. They don't want a bench trial or a jury trial. This is the system of justice we have today. Folks, hope in the year 2017 will bring in hopes to millions of Americans. And the Democratic Party in America will perish like the Congress Party in India. They ruled for many years and everything they touched ended up in trouble. in India. In America, the same thing is going to happen. The corruption mill was in full swing. So what President Trump has to do is clean up the Department of Justice first. We should have career executives. We want honest people in the US Department of Justice. Whether it is Hillary Clinton or President Obama, prosecute them to the fullest extent of the law, not look the other way around. Okay? That's one thing. Secondly, we must have adequate number of justices in the Supreme Court who are active. I don't want to blame anybody. Justice Ruth Bader has already said she is going to resign if Trump becomes the president. And they were trying to pack the Supreme Court with the Democrats. I'm not saying Democrats are bad people. I voted for them 40 years in America, including President Obama at the first election. But sitting here 7,000 miles away from the United States, I know what is going on based on my own experience. Ladies and gentlemen, I want to thank you all. I want you to enter your verdict. I would have asked that 10 jurors in a courtroom to do it, but they won't allow me. Now I want you, ladies and gentlemen, from all across the globe, send me an email, please, an email with your comments. My email address is trdavid2009@gmail.com. If you are a professional, an advocate, a judge, a law professor, law student, send me after reviewing my cry for justice. I am 77. I don't know how long I am going to live, but I would like to die in peace because I got a day in court, which was not possible under that corrupt democratic administration. Okay? I will appreciate, I want to thank you, ladies and gentlemen, once again, for taking the time to listen to my tale of woe. Thank you.